motion. I need time sleeping at the ocean. I'll be fine, stuck in forward motion. I need time sleeping at the ocean. I'll be fine, stuck in forward motion. I need time sleeping at the ocean. I'll be fine, stuck in forward motion. You got the time that you needed, that you needed. You got the heart that you needed, that you needed. You got the time that you needed, that you needed. You got the heart that you needed, that you needed.
Oh no, my kids have to be like that. My
Things you clung to, my soul still hunger for something other, but it's only you. It's only you. It's only It's only you. It's only you. Lying down, let it rush to my head. Spill milk, broken glass. Counted every minute right before you left. Every syllable you ever said. Say it like you mean it till you take it back. Every hand, lying down, let it rush to my head. Spill milk, broken glass. Counted every minute right before you left. Every syllable you ever said. Say it like you mean it till you take it back. Desolate the ceiling.
Everybody in this side of the room to just stand up. Stand up. This will just take a quick second. Let's get our energy going. While you're standing, everybody put your hands out and get them up and down. Fly like a bird. Bounce with your feet as well. Let's get some energy going through your legs and through your hips. There we go. All the people at home right now, you're watching us and thinking, oh my God, what are these people doing? You could join us as well. If you're sitting in your chair, it's 8:45. You might actually just be watching us sitting on the toilet. I don't know. Hopefully not. Put us on mute. All right. Is everybody feeling better? Yeah? You feel like you just flew in from Calgary and boy, are your arms tired? No, Edmonton, Patrick. All right, so I'm going to introduce Mr. Gary Hagel. I sat with Gary for a big part of last year's event, and he knows what he's talking about. So we thought, hey, why don't you tell everyone what you're talking about and come to the stage? We're going to do a great introduction. I'm not going to read his bio and tell you which school he went to and how many designations he has and blah, 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 because most people, A, assume that you have that, and B, really don't care. But what we will tell you is 1 year for Halloween, Gary went out as Dance Dad. So what does this mean? Dance dadding or dad dancing is fun, it's big, and most importantly, you can't get it wrong. You don't need a partner. You can do it to any type of music, and no one is going to correct your technique. So people who do dad dancing, they like to bring joy to the world. And bringing a smile to people's face is the best part of a dad dancer's day. Ladies and gentlemen, this is Gary Hagel from PLLR. Take it away. And if you're joining us in the room, how we talked about the feed loop code that you have to enter, put that in your phones. Go into the feed loop app onto this session. So this will be session 1, track 1. And then there should be somewhere to put that in. Oh, schedule. Sorry? Right, yeah, you have to go to this session and say that I'm in this session. Yeah. And then click on the check-in, yeah.
Hi, everybody, and hello to everybody attending virtually at home, apparently in the Caribbean. Thank you for having me. My name's Gary Hagel. There we go. I'm a lawyer at Pryke Lambert Leithley Russell. I'm a mediator as well. I'm going to be talking to you about issues and potential strategies when you know that beneficiaries in an estate planning situation don't get along. A common scenario, of course, is a blended family where maybe the children from the two sets of parents don't like each other. Maybe one set of children doesn't like stepmom, you know, that sort of thing, okay? Now, so all of my comments are going to be directed at trying to avoid litigation, avoid estate disputes, because estate disputes obviously can get very emotional. As soon as emotions get involved, people become positional. It's very difficult to resolve these disputes, and it gets really expensive. Not to mention it can destroy relationships. So this is what we want to try to avoid. Oh, yes, and most will makers want to avoid this, and I'll pause with an anecdote. I had a client, we'll call her Jane, wasn't her real name. I was helping her with a will, power of attorney, representation agreement, and so forth. And she had me draft the will such that one child, she had 3 children, one child got very little, one child got rather more, something approaching what most of us would consider a fair share, and then one child got the bulk of the estate. She had reasons for it. They were rational reasons. I pointed out to her that, okay, you realize that what you're doing is setting up your children to have a fight. There's going to be likely be a big fight when after you're gone. And I explained the basics of wills variation issues and so forth with her. Her response was, yeah, I'll be gone. So most will makers want to avoid this, not all. Okay, so we want to create certainty. A good estate plan, including a good will, creates certainty. We want to make it so that the executor, the beneficiaries, and potentially the court know how and when an estate's assets are to be distributed. We want to avoid uncertainty because it leads to, again, potentially litigation. All right, so some basics about the Wills Estates and Succession Act and will variation. I'll pause to point out that Krista Simon of Hammerco Lawyers is going to be speaking more on related topics this afternoon. I encourage you to attend. Krista is an excellent lawyer. They're a good firm, perhaps not as good as my firm, but very good. In any event, she'll have more to say about this sort of thing, I expect. So a judge's authority to vary a will comes from section 60 of the Act. And you see what it says up there for yourself. The key is what I've underlined. The judge can alter a will or a distribution under a will so that it makes provision that the judge thinks is adequate, just, and equitable. Okay, so tremendous amount of discretion here. And as a result, a cautionary tale. This comes from my own firm. So under the Act, a disgruntled spouse or child, not an adopted child, not a nephew, not a charity, a spouse or child can bring an action seeking to vary the distribution of the assets under the will. All right? There's a great deal of discretion in terms of whether the distribution should be varied, and if so, how. So in our case, one of my partners took a matter to trial. So there are 3 counsel. Each had a different opinion as to what the outcome was likely to be. They went to trial. The judge gave a 4th outcome that nobody predicted. It went to appeal, and the Court of Appeal did a 5th thing. This is something that your clients and mine need to be aware of. All right. So there are various ways that somebody can challenge the will. One is alleging undue influence, and I'll be coming back to this in a little bit. Okay, basically, when someone gets a much greater share under a will or a share of an estate, the other people often allege that that beneficiary unduly influenced the will maker, pressured the will maker, bullied the will maker, call it what you want, so that it wasn't the will maker's independent, genuine intention to make that distribution. They were pushed into it, basically. Okay, but this is very difficult to prove. Another way is that, or to attack a will, is to attack the will maker's testamentary capacity. So did the will maker actually have the mental capacity to make the will make a will at all, and in the way that he or she did? Okay, testamentary capacity is it's a legal test. It's not a medical test, and it's quite easy to prove, actually, that somebody had capacity. It's beyond me to get into exactly what that is here today, but I'll just point out that that's one of the ways that somebody can attack the validity, the underlying validity of the will. Okay. Now, if a will is ruled valid, or pardon me, invalid due to incapacity or undue influence, what we then end up with is either an intestacy, meaning there is no will, okay, or if there was a prior valid will, that will may govern. Okay. Now, in the absence of a will, we get the intestacy situation. Okay. And sections 20 and 21 of the Act determine who gets what. So this may be entirely contrary to what your client wants, right? This is another reason we want to try to avoid it. And here you see what it says, okay? So the spouse gets a preferential share of the estate. And if all descendants referred to in the prior subsection are descendants of the intestate, so the deceased person and the spouse gets $300,000 or a greater share if prescribed. There is no greater share thus far, okay? But essentially this share can change. If all descendants are not common to the deceased person and the spouse, then the preferential share is only half of that, okay? And then I'm going to skip what else follows. The key thing to remember here is that these sections do not make provision for anyone who is not a spouse or a descendant. And a descendant is a blood descendant. You're following the bloodline. So no adopted children, no nieces, nephews, cousins, no charities, no good friends, nobody like that, okay? So how do we get around this? One is inter vivos gift. An inter vivos gift is simply a gift made during life. So I can dispose of my assets as I want during my life. I can give my child $100,000. I can give one child something and another child nothing, what have you, okay? So those are gifts, and I'll get back to those in a minute. But we also have joint tenancy and joint accounts, all right? People are often keen to avoid probate fees. They see them as taxes, and they think joint ownership is a good way to avoid that. They might also see it as a gift. They're giving their child a preferred share. In other words, preferring the child over other children, sometimes for rational reasons, sometimes for irrational reasons. But in an estate situation, joint ownership can lead to problems, and you can end up costing a lot more than they're worth. Okay, and I'm pretty sure there's someone else speaking on joint ownerships today. So we got this classic situation where a parent adds a child to the parent's bank account so that the child can manage the financial affairs, or potentially as a gift. Again, my son or daughter has looked after me in these last 5-10 years of my life, has taken me to medical appointments, has supported me emotionally, etc. I want him or her to have this, this TFSA. It's got $200,000 in it. I wish. Okay, so or the parent may put the child on title to their home or a piece of real property as a joint tenant, right? Now, when the parent dies, in theory, the ownership of the account or the piece of real property passes automatically to the child. But it's just a theory. So let's consider the situation where by the time of the parent's death, the estate has changed a lot. The value of it, I mean. It may have gone up, it may have gone down. Maybe they died within the last 2 years and their RSPs have lost 30%. Maybe it's simple financial mismanagement. We don't know. Okay, sorry, I've skipped ahead here. Or it may just be that the parent lived longer than they thought they would and they eroded their estates. Bottom line is other beneficiaries may challenge this joint tenancy, this joint ownership, right? Because again, remember, other beneficiaries may feel aggrieved. So now we get to the Supreme Court of Canada case in Picor versus Picor. In this case, the court was dealing with a situation where a father put a child's name on as joint owner of some financial assets. Okay, the bottom line of the case is that there's a presumption of what's called resulting trust. So if I put my child as joint owner on my bank accounts for no consideration, and it's not it's not clearly documented as a gift, there's presumption that the child is holding it in trust for the estate. Okay, what that means then is it goes into the estate and it's distributed under the will. It doesn't go to that child. A word about gifts. Okay, you can document one of these transfers, adding a child as a joint owner. You can, and if it is meant to be a gift, you must clearly document that by a memo, by, you don't attach it to the will, but you have a memo stored with the will, by the clear notification or recording of your client's instructions to you. Okay. But at common law, a gift, when there's a gift, a significant gift, there's a rebuttable presumption of undue influence. So if someone's challenging the gift and they show the appropriate circumstances which lead to this presumption of undue influence, now the legal burden shifts to the person who received the gift to show there was no undue influence. Okay, so gifts, again, are an imperfect solution, which brings us to trusts, which are perhaps a better solution. So trusts, as I'm sure you're all aware, are popular estate planning tools for purposes of tax mitigation, probate fee avoidance, and so forth. They can also be used in a non-testamentary or inter vivos manner to make distribution of assets which would otherwise not comply with the common law and statutory duties on a will maker in terms of making just and adequate provision for spouses and children. Right? As recently as 2006, in a case called Mordo versus Knitting, our British Columbia Supreme Court explicitly approved of trusts as a means of managing dispositions, including even disinheriting a spouse or a child. So they can function effectively that way if that's what your client really wants. But like wills, trusts can be challenged on the basis of undue influence and capacity. It's a different test of capacity for inter vivos gifts and trusts than it is for a will, right? And I'm not going to get into that today, but they can be challenged. Again, undue influence is difficult to prove, but it still can be challenged on that basis. And again, what I'm getting at is it's still imperfect because a disgruntled beneficiary or potential beneficiary can challenge the trust. So I haven't given you much hope so far. Look, the reality is that there's no perfect solution, okay? But these are all the different ways that people try to get around it, and there are ways to try and make them succeed. If it's a gift, document it again. Make it super clear that it's a gift when we're talking about these joint ownership situations. The trust, rigorously assess your client's capacity to make the trust. Make sure you engage a competent trust lawyer to make sure that the trust itself meets all the legal requirements necessary, certainty of intention, certainty of gift, etc. Okay? But it all may still go to hell. So one way that's relatively new to approach these situations during the will maker's life is essentially a family mediation. Full disclosure, I'm a mediator. It's in my interest to talk about this stuff. Well, it's a tool that, in my view, could be used more. Basically, the premise is the will maker or will makers, because you might have mom and dad, and they're doing the estate planning. and the children or other beneficiaries get together in a mediation setting. So you have an independent mediator, you have the parties there, and the idea is to work out an agreement. It's kind of analogous to a prenuptial agreement or a cohabitation agreement in a family law setting. The idea being that mom and dad, in a safe environment, explain what they want to do and why. The beneficiaries, in a safe and respectful environment, explain what concerns they have about that, why they think perhaps it should be done differently, etc. And the whole point is to try and get buy-in from everybody in terms of what mom and dad are going to do, or just one parent if there's only one parent remaining. Again, most will makers want harmony and peace in their later years, and they want to ensure harmony and peace after they're gone. And that is what this is supposed to do, because you get agreement and hopefully acceptance of what mom and dad are going to do in the will. So what's the effect of all of that? If you get an agreement, it doesn't create a will, but it does create an agreement as to how people are going to treat the will, assuming that the will maker does what he or she says they're going to do. It's not binding on the court in terms of the will maker's obligations. However, if it's done properly, and this is true of any mediation, it creates an agreement that is at least binding on everyone's conscience. And most people abide by agreements that they have signed, that they have participated in the creation of. Right? Again, and also if it's done properly, it can result in an extra testamentary document. So in other words, a document that's not a will. It's not part of the testamentary process. It's not unlike, though, what I was just telling you about documenting a gift. Have a memo, have your notes, have something that the court can refer to, which is why I talk about a memo, because then your client can keep it, maybe with the will, not attached to the will, but with the will. This is a similar thing. Your client keeps this. We have this agreement in place. It's signed by everybody, minutes of settlement or a settlement agreement. And it sets out, therefore, a rational basis for why the will maker did what he or she did in his will. So process is paramount. Everyone needs to be allowed to express their concerns or views. Everyone needs to feel heard. You can't control how anyone's going to react, of course, but you need to at least set out the process such that they have the opportunity. Everyone must be insulated from bullying or undue influence. Parents maybe have to be separated from everybody else. Maybe it's a shuttle mediation where the mediator is expressing the parents' wishes without the parents being in the same room. It all depends on the dynamics. And you have to tailor the process to suit the specific situation. But again, the key is you have to remove any potential specter of undue influence, because you want an agreement that's going to be viewed as binding. Everyone should be given the opportunity to have a lawyer with them. Lawyers, of course, can complicate things a little bit, but hopefully you've got, again, everyone buying into the process. And if they have competent collaborative counsel, then counsel shouldn't get in the way. And again, that's part of what the mediator's job is. As a mediator, I'm trying to keep everybody on track, right? I'm trying to help people reach an agreement. And sometimes that means managing their lawyers, mostly not. But again, the key is that everyone has to feel like they have an adequate chance to express themselves. And of course, they're going to need legal advice. So even if they don't bring a lawyer, they have to be given the opportunity, and that must be documented. The minutes of settlement should be drafted by the lawyer who will be drafting the wills, along with any other documentation regarding how and why the assets are being distributed. And the lawyer must make sure that the will actually follows the minutes of settlement. In terms of evidence, as a mediator, as mediators, we would not keep any of our notes about what anybody said, offers back and forth, or anything like that, okay? That's all privileged. But the process, how it was set up, that everyone was offered the opportunity to get legal advice, etc., that can all be documented and that can all be retained and kept, because that's not privileged. It's just a fact. Same with the minutes of settlement. All right, so what then? Well, we need to talk a little bit about extra testamentary documents. And again, this also takes us back to what I was talking about when I'm talking about joint ownership and is it a gift or not? In assessing the distribution under a will, in other words, whether the will maker made just and adequate provision for spouse and children, the court is free to take into account extra testamentary documents. And under the Wills, Estates and Succession Act, which now isn't all that new, but it brought something new in, which is that the court can take into account extrinsic evidence. In other words, evidence outside of the will. So the will maker can provide a document, usually a statutory declaration. I've done many of these, which sets out why he or she is leaving less to Johnny and more to Betty. And as long as it sets out a rational reason, rational basis, founded in reason, that doesn't violate social norms, then the courts are likely to give that deference. You can't disinherit someone because they married the wrong person. You can't disinherit someone because you disagree with their sexual orientation. But if someone has been abusive to you, or they've just separated themselves from you, they haven't been in touch with you for 30 years, you can lay all that out and the court will take all that into account. So that's a statutory declaration. Minutes of settlement from a family mediation would have the same effect, right? Here's the distribution under the will. Here's why I did it. Here's everybody who had a say in that. And here's what the agreement was. So the court can look at that and they can give that deference. So again, hopefully it's binding on the conscience of everyone who agreed. If it's not, and one or more start an action anyway, this goes to their lawyers. The estate lawyer says, but look, right, you've now created at least greater certainty for the estate and increased uncertainty or risk for those challenging it. You are more likely to reach a resolution short of trial. So, as I said earlier, I haven't given you a lot of hope, or I hadn't early on, because frankly, there is no easy way out. It's a problem. It's an increasing problem because of the increasing prevalence of blended families. Sometimes people just don't get along. And there's a sense of entitlement from the first group of children, maybe. You know, and there's also the wicked stepmother is a cliche, but a lot of people just emotionally look at the stepmother or stepfather as wicked. You're not my mom. You're not my dad. So it happens. All we can do is manage risk. So when we're talking to our clients, when you're talking to your clients, you got to go through these options with them, whether trust, gift, mediation. And you want to avoid what I'm calling post-mortem surprises. You want to try and achieve consensus. You want to try to achieve peace for your client. So these are ways that you can possibly go about it. You might not be able to avoid conflict, but if we can at least limit it, then we've given our client something of significant value here. Excuse me. I forgot to mention, I'll just make one last comment before I sign off here. A word about joint tenancies. if your client puts their child on title to a piece of real property, maybe the family home, as an owner, that child is now an owner. And that child's creditors can come after it. And that can create real problems for your client. There have been some tragic cases where mom or dad in their later years is now facing a partition and sale of their home because they didn't realize that their child had huge debts or a gambling problem or something. So just another risk to make sure you advise your clients about joint tenancy. Okay. I don't really have much more to say. The conclusion really is there is no easy way out, but there are options, and I've discussed some of them. So I hope that was of some interest to you. It's difficult to be the first. I always feel like I should be entertaining. If I wasn't entertaining, then at least it was of some value to you. Thank you. Okay, we have a question, yeah?
With the joint tenancy, what about the family property is not part of the divorce proceeding? Let's say the child gets divorced. Does that play a part? Has that become part of the divorce proceeding?
So for the benefit of people who either at the back of the room and couldn't hear, and those of you at home or on a cruise ship, the question is, yeah, I'm not letting you live down the cruise ship thing, whoever you are. The question is, what about a situation of divorce? So I think what you're getting at is, if somebody gets put on title as joint tenant, a child, and then that child gets divorced, what's the impact of that? Now, are you asking about during the will maker's life or after death? Well, that can create real problems. You'd want to talk to a matrimonial lawyer about that, okay? But as the title exists, the child is a co-owner of 100% of that property. Now, the child can't do anything with it without severing title. Again, you probably all know this, there's joint tenancy and tenancy in common, both co-ownership situations. So somebody would have to sever title so that it became a tenancy in common before anyone could do anything with that child's interest. But yeah, it can create stress at the very least. I'm not qualified to talk about whether in a family law situation, the spouse of the child could actually force a sale or go after that. But I would expect at the very least, it would form part of the analysis of assets, who has how much money, and that would get into the support considerations, you know, because it's an asset, you know, and if it's a home in East Vancouver worth $2.5 million, and there's a reasonable expectation that the child is going to inherit that in the next 5 or 6 years, well, the spouse is going to want a part of that.
If anybody here is joining us virtually, if you want to ask a question, you can put it in the chat and the comments for this session, and we're monitoring those and we'll bring them up.
Yeah, at the beginning, you mentioned, I think there might be, or maybe I misunderstood, a difference between a blood lineage child and an adopted child. Can you just elaborate on that, please?
Yeah, sorry, if I said adopted child, I got it wrong. Under the Wills, Estates and Succession Act, a child or a spouse can challenge a will, a distribution under a will. Child will include a legally adopted child. I apologize. It will not include a stepchild unless that child has been adopted. The one thing about adopting a child that the parent and the child need to be aware of is that if you adopt a child, that child is now your heir and no longer the birth parent's heir. That's something to keep in mind as well. Yes.
My question is, we have preferential share for the spouse. If the intestamentary happens, but my question is, what if the guy in a will doesn't give that much as preferential share to the spouse? Can they revoke the will after death or not?
I think the question, if I understand you, is if there is an intestacy.
Not intestacy. Let's say in intestacy, it's clear. okay?
Yes.
But when the guy has a will, but in that will, he doesn't give that much according to preferential share to the spouse.
Right. So the question is, what happens if in a will, the will maker does not leave that preferential share of $300,000 to the spouse? The answer is the will, that section of the Wills, Estates and Succession Act doesn't apply. Okay, keep in mind that the estate might not be worth $300,000. So it's not about whether the will maker leaves a preferential share or an amount equal to the preferential share. It's all about whether the will maker has made just and adequate provision for those people to whom he or she owed a moral and legal obligation. Okay. Under the Wills, Estates and Succession Act, the only people who can challenge the distribution under the will are the spouse, and there's a specific definition for that, and there's plenty of litigation about whether someone was a spouse, and children, which, as I've just explained, includes adopted children, but not stepchildren.
Okay, thank you.
Okay, so it all comes back to whether the will maker made just an adequate provision for those people. It has nothing to do with the Wills, Estates and Succession Act, unless there's an intestacy.
Yes, I have a question regarding irrevocable beneficiaries on registered assets. They're becoming very large amounts of money today.
Yeah.
It's not uncommon to get 2.5 million, 3 million in an estate. But you can have an irrevocable contingent beneficiary. You can have an irrevocable beneficiary. What would be your comments about the status of that type of beneficiary, which is pretty absolute and you've signed and agreed to?
So you're talking about you're talking about a financial instrument where the bank or the financial institution has provided a form and the owner of the.
I'll give you an easy example, so it's actually pretty specific. You have a couple, they have, their second marriages in both cases, children and so on, and they want to roll over to the spouse,
Right.
which is the successor owner or whatever, annuitant, and then you want to name divide whatever's left between the children in some formula. Let's say it's equally to the 6 children. They're named as irrevocable contingent beneficiaries. So the rollover to the spouse would take place, but that spouse then cannot change the beneficiary. It is irrevocable. And there are ramifications of being irrevocable beneficiary, I think, so you might want to comment on that. But I'm seeing that appear quite frequently now on some of the legal profession is recommending.
Mhm.
So I was just wondering what your thoughts were on that particular process.
Well, okay, so you're talking about a situation where any remaining capital in the asset at the time of the spouse's death, the second to die, any remaining capital is then distributed to the contingent beneficiaries, right? It should be enforceable. What will come back to, I mean, it may be a consideration later when the judge says, okay, did the first to die make adequate provision for all the children, right? They'll take into account perhaps that there's this $2 million asset that goes to these 2 children and nothing to this third. Okay, right? But it should be enforceable unless someone challenges the beneficiary designation on the basis of undue influence or something. But considering that it's going to the spouse first, and these are just contingent beneficiaries, and we don't know what the value of the asset will be at that time, I would think it's a good strategy.
There is a complication, I think, in that you can't make any changes in your income, investment, without all these beneficiaries agreeing to it. So there's a negative side.
Yes, there can be. And also, if you've set it up as a trust as well, then you get into issues.
It's not a trust,
It's okay. So, it's just an RSP. All right. Yeah, there are administration problems as well. I think I'm afraid I can't answer that for you right now today. If you want to email me, I can look into it. But in terms of just an estate planning tool, I should think it would be valid and a good way to go. Again, nothing is bulletproof, but it's a beneficiary designation on a financial instrument.
Along the lines of that, there have been a couple pieces of case law in BC, Ontario, and I think Nova Scotia. So I'm referring to Mac versus Mac, Fitzgerald versus Fitzgerald, and I think Samard. Anyway, so these are beneficiary designations made on, again, financial instruments. I think they're RIFs, and or in one case it was a RIF. And although it was beneficiary designation, not joint ownership, the courts have been sort of wishy-washy on the resulting trust or presumption resulting trust issue. Can you speak a little bit about that and where we're at with that now? And what can we as advisors that are, following or abiding by our clients' instructions, how can we kind of forewarn them about that? And what should we be doing as far as like in our notes and our client notes and things like that to make sure that the client's wishes are met?
I can say a little bit about that. Right now, it comes back to what I talked about earlier. You're quite right. I mean, courts tend to be wishy-washy. There's a great deal of discretion. It's all very fact specific. And so it comes back to documentation and clarity and comprehensiveness of documentation. Is this, and from your perspective or from the perspective of the lawyer advising the client, you have to be aware of the signs of undue influence and check for them. There are checklists available that you can say, what's going on here? You ask certain questions, have to be aware of capacity and so forth. But the basic principles are the same. If it's a true gift, it has to be well documented. Otherwise, there may be a presumption of resulting trust. I mean, the PCOR decision has been applied quite broadly. It was in the context of various investments, but it has been applied to real property here and in other situations because the principles are of general application. So it's probably not a great answer for you. I mean, you said yourself, and I think accurately so, that the courts are wishy-washy. They go back and forth. You're going to get differences between jurisdictions. You're going to get differences within jurisdiction, within the same jurisdiction, because it is all so fact specific. Documentation, documentation, documentation. I just keep coming back to that. I hope that's a reasonable answer for you.
Hi, Gary. Thank you. I always love the lawyer part of this because we get into the cases. I'm wondering if the statutory declaration, if people are using that towards, like if they have a child with addiction or mental health kind of issues.
Yes, people have done that. Again, the court will take it into account. The court will examine the circumstances. Mental health issues and addiction issues are thorny topics, and the courts struggle with them because essentially the courts ask the question, well, okay, Gary, your child, is a meth addict, and you haven't heard from him, or he lives on the street or whatever. Okay, does that mean you should cut him or her out of the will? Like, is it an illness or is it a moral failing, right? Also, there's the question of, well, what happens by the time Gary dies? Is that child still, in those circumstances? I have a file right now, a will's variation claim, where the daughter was cut out of the will completely. Actually, two of three children were cut out of the will completely. But the situation has changed dramatically in the 15 years since the will was done. Right? Like there's just no way this distribution is going to stand. So the statutory declaration, all it does is set out the rationale for it. A better way to deal with a child with addiction or mental health issues would probably be a trust. So because that child can't really effectively manage his or her affairs, there will be a certain amount of money set aside in a trust for that child's lifetime. And if that child eventually recovers from addiction, manages to control or find not a solution, but a means of controlling and managing their mental health issues, then perhaps they can apply to the court or to the trustee to have the capital paid out. But that's a better way to go when you have a child with addiction or mental health issues, similar to dealing with an adult child with a disability of some kind.
They don't have the capacity to hire lawyers or anybody like that. So does the public, you have to send the file off to the public trustee in some of those cases when you're filing. But do the public trustee get involved very often in cases like this to defend the rights of the disabled person?
Okay, so the complete question was, what if you've got a situation where somebody's disabled such that they can't manage their own affairs, and the public guardian and trustee has to get involved? Will they be vigorously involved is basically the question. The answer is yes, they will. Anytime you're administering a will or seeking probate of a will that involves an infant or anyone else under a legal disability, you must notify, the lawyer must notify the public guardian and trustee. They have to basically, first of all, they have to approve or give comments as to whether the will actually ought to be admitted into probate and whether the executor ought to be confirmed as executor. They generally don't comment on that last issue at all. It's more about whether the materials that have been submitted are adequate, whether they have any objections to the will, et cetera. Then when it comes time to administer the will, yeah, they will be involved. If basically on an oversight basis to make sure that the disabled person is being looked after. In the case of an infant beneficiary, a legal infant, I mean, anyone under 19, typically you can have the will, depending on the size of the estate, you'd create a trust, right? So it can either go to a trustee or, depending on the circumstances, you might draft the will so that the executor can pay out to that child's parent, trusting that the parent will look after it. But there was a recent case where the parent didn't look after the child and the public guardian actually got involved, started a lawsuit, and the parent now owes the child something like $750,000. So the public guardian will keep an eye on things for sure.
Gary, we have 2 questions online.
Oh, okay.
Actually, well, let's do the one in the room first and then.
Yeah, Gary, just want to keep along that same vein. So, for example, you have a child who has addiction issues. The parents have spent, let's say, $500,000 trying to get them treated. Now they're gone. They put in their will, we're reducing our amount to this child because we spent this amount. Will that hold up if there's proper documentation?
Will it hold up? Who knows? Can't guarantee it. Is it likely to? I think so. Because again, it comes down to that documentation, and it's not simply we're reducing this child's share because we disapprove of their lifestyle. We're reducing this child's share because we spent $500,000 on them already, and our other children shouldn't suffer for that. So that's something that I would call, and I would certainly argue if I were the proponent of the will, that that's a rational basis for the distribution, and the court ought to defer to it. Because again, remember that the test is just an adequate provision for the children, right? So they're saying, well, I want to treat all my children well. We've already given $500,000 to Gary, in effect, right? So we don't want Ellen and Felicia to suffer for that. So is it bulletproof? No, nothing is. Is it a strong reason? I think so. It depends, again, it depends on the facts of the case and how the judge, and frankly, how the judge views it. But yes, that would be, you'd want to very clearly spell that out, and you'd probably want to have some detail about when and how the payments were made and to whom and so forth, so that years down the road, that child can't say, no, they didn't, you know, and doing it at a time when that evidence isn't available. So 2 online questions, you said?
Yes, I'm just gonna read them off.
Yep.
So Bill here asks, can Gary please comment on what he means specifically about adopted children not counting as children? Or was he meaning stepchildren into a blended marriage? I have a birth certificate with my name on it and the BC court documents finalizing the process of being the parent to the child. Are you saying that they are not considered children as to my estate?
That was the same question that the fellow down there asked. Yeah, I got that wrong, and I'm terribly sorry. You know, legally adopted children count as children under the Wills, Estates, and Succession Act, and therefore they can challenge the distribution under a will. Again, to Bill, I think you said his name is Bill. I'm terribly sorry. You're the second person to catch me on that, so you've doubled my embarrassment. Well done.
I have Blair here asking, Gary talks about a trust as being a God option for an addicted child. Is he referring to a testamentary trust?
Yeah, it could be either testamentary or inter vivos trust. An inter vivos trust can be used to set up a trust fund to maintain your children or a spouse, you know, for years and years, or it can be a testamentary trust. But in that, when I gave that answer, I was specifically speaking of a testamentary trust. Again, I have a couple of cases involving that exact scenario.
All right, everybody, last chance for questions. Thank you so much for asking so many questions. The worst thing is when the speaker says, and I'm done, any questions? And crickets. So this was actually really good, and it shows the engagement and the importance of this topic. Going once, going twice, anybody in the room? Do we hear? No, anybody virtually at home? This is your last chance.
And while we're waiting, I'll just say thank you. They were good. These are good, insightful questions. So thank you for that.
Yeah, and thank you, Gary. If anybody wants to talk to him, you can message him through the app or speak to him. He's sitting in the room.
Yeah, I have 4 minutes and 40 seconds. So I want to say one thing.
Oh, he's a lawyer.
This Dance Dad business. I didn't write or say what Laurent wrote or what he said about what dad dancing means.
Oh.
I don't necessarily disagree with it. Certainly my style of dance could be considered a dad joke. Certainly my children feel it's that way. The story is I was forced to give to say what my best ever costume was. I don't wear a lot of costumes. 1 year when both my daughters were still in dance, I decided I would go as Dance Dad because I was a dance dad. So all I did was I got a tiara and I borrowed just a, like a tutu, but with, I don't know the fabric. I'm sure there are people here who do, but that kind of gauzy fabric, and it came down to here. And so, and I think I might have had a wand or wings or something. And so I just went out trick-or-treating with my kids, and that was Dance Dad. Okay, that was it. And what was interesting to me was the reaction that I got from different parents. The women universally loved it. They thought it was sweet. A couple of guys couple of guys commented, oh, that's cool, that's awesome, you know, and a couple of guys were clearly freaked out by it. So anyway, it was an interesting experience. So thank you very much. I appreciate it.
Thanks, Gary. That was great. And thanks for the clarification on the dance dad. I just read what's on the paper. Yes, yes. So Gary has given us an extra 3 minutes if you want to get some coffee, get some water, go to the bathroom. If you want to switch rooms for the next track for whichever. Our next one starts at 10 o'clock. I don't know, but push the button. Yeah, check out if you can. Or maybe give it 2 minutes so that it shows you were here for the full hour. Yeah. So we'll be back for the next session will start at 10 o'clock. So please come back a couple minutes before 10. Thank you so much.